Actually, one of the things I really liked in the chapter was on the balance between security and liberty. I took your argument to be our security will be increased and their liberty will be taken. And of course the our is in a way the general Australian society. The there is one group of that society, the Muslims,
Yes.
who have come, I think now everyone would have to be asleep to not think that in general a language has developed and a set of suspicions have been aroused which affect far more, let alone terrorists, far more even than those who are sympathetic to a certain kind of jihadism or even in their minds are sort of attracted to the wickedness of the West and the need for Islam to do something about it. Could you say a little bit about that? Because I mean that for me is the most persuasive argument against the language of balance, in that I tend to agree with you, if I understand you rightly, that most of the measures that have been taken in the war on terror in Australia will not affect the ordinary citizenry much, except in a very subtle way in our rethinking about what the rule of law means, but in a way that's rather imponderable. But where things do affect, in a present day, a certain segment of the society, it's the Islamic sector.
Yeah. I think that's it's not my observation, but I think the argument's right, which is why I used it. A number of people have, particularly in the United States, where a lot of people have been, have made that point. But again, it's a matter of use of words. It is very beguiling to be told, look, we've all got to tighten our belts a little because the situation, the threat is serious, and liberties which were not luxuries in luxurious times, which we thought were very important, we have to recognise we will have to curtail or live with some inroads on when times are tough. But that's not actually how it's going to play out. My liberties, your liberties have not, yours perhaps more than mine, but my liberties have not suffered an inch, and won't, presumably. But some people's, both, given that terrorism has both this immediate physical dimension, who gets killed, and a larger psychological dimension, which is what it's about, then it's worth thinking that counter-terrorism has also a psychological dimension. And its psychological dimension even, quite apart from the physical one, doesn't hit me. And only because I'm completely unexceptionable.
Yes.
So, unexceptional, the other two.
That's for others to say, Martin.
Yeah. But there are going to be target populations. And if liberties matter, and if we use also a language of rights, but increasingly, even in extremes, which we're not talking about here, the right not to be tortured, increasingly the language we talk about these things in is as though right had no value. No, wait. To call something a right is just to say somebody wants it. But it's not. I mean, there are reasons why we call certain things rights. We don't want them mucked around with because they're very valuable for the dignity of persons, for various other reasons. Now, if we have a target population which is presumed to include some dangerous people, it's a presumption, and is also known to include a lot of people who aren't dangerous, then it seems to me that the language of the balance of security and liberty is fraudulent in regard to what occurs when my security is arguably, I don't think in any way proven to be, increased by the decrease in liberty for a target group which will be presumed to include dangerous people, but is also known to include many non-dangerous citizens.
Yeah. One of the other issues that you deal with in the chapter that interested me a lot, but I wasn't entirely sure where your balance in the end lay, is the question of how far the law before September 11, 2001 was adequate to the new problems. You quote on the one hand David Neal, SC, who I know is a friend of yours, who really thought that the argument that somehow the law, the ordinary criminal law, couldn't preempt, didn't have the capacity to act in advance of criminal behaviour is a false argument. The law has often found ways of dealing with things that haven't yet happened, but which are being planned. So that's on the one hand. On the other hand, you do say that it is a sort of prejudice of the civil libertarians that law must never change, that new situations arise, and in those new situations, new things have to happen. So I suppose I want to raise with you the whole question of how far the law as it existed without the addition since September 11 was adequate to the problems and how far it wasn't.
I'll be oblique in the answer because I'm not a criminal lawyer, and I think you have to know the way the text, how far you can push a provision in a court, which I don't know, but I do know the arguments a bit. Somebody like David Neal, who has put this forth, who is a criminal lawyer, not a criminal, but a lawyer who deals in criminal law, his argument is that there are a range of criminal offences, some of them quite controversial when they came in, attempts, conspiracy, possession of certain sorts of things, which already are on the books, but are subject to, even though sometimes they press the boundaries of, criminal constraints. That is, there's got to be a connection with a provable offence, that offence has to be proven beyond reasonable doubt, etc. And he says, you didn't need more.
At all? Does he say
I think
it as
that's his
flatly
line.
as that?
He says it as flatly as that.
But the law before September 11 was fully adequate to counter terrorist behaviour.
Again, it's not a false modesty or even a real one. I don't know the texture of the criminal law well enough to say confidently that you don't need that everything that you might want to capture done by terrorists would be captured by that. But I do make some observations. One is, if you're objecting to new laws, it can't be just because they're new laws, because we have those every day.
Because it happens all the time.
And we have new criminal laws every day. And we didn't have much law about IT offences and a whole range of things to do with software, and all sorts of things keep happening.
The world changes and the law has to respond.
That's one thing. And so if you've got an objection, it can't be just to that.
Yes.
Secondly, the authors of a good collection, summary account of the Australian law, Andrew Lynch and George Williams. I was talking with Lynch, and he thought, in relation to David Neal's position, that at least you could have the existing criminal law, but the penalties for many things should be increased for terrorists because terrorists are targeting they're targeting the whole of the society.
And their purpose is different in the way you were saying earlier.
So I think that would be an argument for among specialists a bit, but I think there's something in that. A third point is that terrorists, for the reasons we mentioned, aren't just ordinary criminals, and maybe you've got to give some weight to that. But my main worry, and here I come back closer to David, but at a different level, is that it's not the specific laws that you add. It depends on those specific laws, but it's not the fact that you're adding specific laws which is a problem. If the laws you add violate in certain deep ways underlying principles which are written through the institution.
Give me an example.
Everything has to be proved against a criminal beyond reasonable doubt. A presumption of innocence. The accused has to know all the evidence against him and so on, which is now, because of
things
national
really
security,
deep in our legal tradition.
Independent arbiter. Now these are semi-independent. There are certain circumstances in the new laws where retired judges, approved by the Attorney General, will sit on certain applications. These are presumably decent fellows, but they're not independent in the way that we spend a long time making them independent in the system. And when this is all dressed up with the kind of Attorney General's rhetoric that this is just what it means to be tough-minded and serious about a response to terror, let alone the more speculative but strongly argued for view that, look, a little bit of torture in the right place or in the right circumstances is something we could contemplate. Then it goes back to what I was saying before. The law, a valuable and decent legal system is not just the specific rules. It's the sorts of things that people who are imbued with that way of thinking will consider beyond the pale. And that's not always a matter of, oh, well, there was this rule or that rule.
Yes.
That is, we don't do this sort of stuff here. And I think that there is a danger, and you called it subtle. It is subtle, but because it's in institutions, and because we'll have laws which violate some of these principles, which won't go away as soon as somebody declares terrorism is off now.
Yeah.
It's hard to imagine. Some of them have sunset clauses, but the sunset clauses, as we saw last year, can be pushed on. So when they were supposed to be, I think, 2006, they're now 2016. So my worry is more not that we have new provisions, but that every provision should be thought about very, very seriously in terms of its fit to these fundamental
Yes.
principles that I...
And is your position then that in ways that we can't yet know, doing certain things that violate certain very fundamental parts of our tradition, our ways of proceeding that have based really, because our law comes out of the British system, based on hundreds of years of thinking, that in ways that we can't yet know, our sense of the rule of law will change. We'll forget things that we'll no longer think to be fundamental, things that we now think are fundamental, yeah. And so on.
I think that this may be a bit complicated because it relates to other things that I think about. You know that I do a lot of work in screwed up countries, or try to, where the ambition is to generate legal systems which really make a good difference. They restrain power where power wasn't restrained, etc. And in that work, I've often criticised people who think, look, we've got this identical kit, say the British criminal law, we'll just carry it over, because it's not, for all sorts of reasons, those sorts of grafts aren't going to take. And what I advocate is think more about what you have in mind, what's the point of this, and then when you go there, say, well, how do they do it, and what have they got? And what you come up with may be very different from what you find in England or Australia, because the traditions are very different. You've got to graft, even to change them, you have to graft onto them. But I started to think, that's a pathological situation. Transplanting legal values and legal institutions to societies which are screwed up. If you are the lucky beneficiary of a strong and good legal tradition, and I take us to be, and the British to be, and the Americans to be, and many West Europeans, then often you can't work out what the point is apart from the institutions. Nobody actually came to Britain with a clear view of what's the purpose of law and then built these building blocks. No. These things have come over trial and error. We're not so smart quite often. If we monkey around with defences and protections that have, I think, often been proven to stand the test of time, then we're monkeying around with something dangerous.
But there is a danger that this will kind of, as it were, act as osmosis, will move out into areas quite outside the war on terror.
I think it must, because that's what legal values and legal institutions do. You don't just have them in a block. And in particular, if you allow yourself within the law to do things that you didn't allow yourself before by saying, well, this is special, then you've lost the defence of saying, well, we just don't do things like that here. Yeah. And I think,
this is the argument used against torture under any circumstance.
Yes.
Is it not?
It's a sort of legal archetype. We don't do that. Yeah. And once we do that,
then we change.
We change.
Even if we say we're only doing it.
Yeah. And there's a sort of, in the spirit of the age, there's something, we're all into purposes now rather than values. So universities are much more now driven by some conception of effectiveness and efficiency and getting jobs done, where once they were undergirded by values which were thought particularly appropriate to them. And that's the way everything works now. Law is moving in the same direction, why wouldn't it? And I think that if you think the values are precious, and I think some, particularly in the area of criminal law, some of the values of making sure that nobody is bagged to the best you can, nobody is bagged for things they didn't do, or bagged notwithstanding what they did,
Yeah.
then you've got to hold on to those and
Yes.
not think that you're so smart because you've got a particular problem that you need to deal with.
Now, can I just two rather practical prudential matters? One is I was very taken with that. We have all sorts of ways of procedures at law, and the defence you make of continuing with those procedures and not fiddling with them or monkeying with them, as you've just said, is that just like nurses or doctors or people who fly aircraft, people who work in the law or policing are error-prone.
Particularly in emergencies.
Particularly in emergencies. I'd like you to say something about that, but perhaps, it seems to me most Australians will now have a very vivid example of this with Dr. Hanif.
And Dr. Ul-Haq.
And Dr. Ul-Haq.
Yeah.
Say a little bit about this, that in a way, all sorts of procedures were built into the system because of a recognition that police and the law are full of fallibility.
Yeah. This, in a way, though I don't think it's a fatal inconsistency, argues in a different direction from my distinction between values and purposes. I'm saying where I was talking there, not in the paper, but today.
Yeah.
If you think the value is important, very often you're going to institutionalise it, even though it makes it harder to achieve certain purposes. And that's why, as you'll see, every administrator in the state government, federal government, hates every administrative lawyer because it gets in the way. The administrator has all these considerations he's got to keep in mind, and these finicky lawyers just talk about one case or one right. Or that is a tension. On the other hand, I think a deeper view is that, and we have so much evidence. President Castro has just stood down. We have the history of the Soviet Union. We have a lot of governments where people thought the best way to get a good result is to let good people just go for it. And in a much more muted, obviously, way, I think that that's a kind of operational logic of people who are involved in high risk and high pressure activities.
Yeah. And we're all prone to say, let ASIO do their work.
And it's not because I think ASIO has unimportant work. I think it's crucially important. It's not because I've no idea who is in ASIO, and I've got no reason to believe that they're bad guys. None. But I think there is an operational logic of, particularly when the logic is seen as preemption rather than after the event catching.
Yes.
Which is, look, if we're after preemption, these guys do their work in secret, they like surprise, that's what they do, then all this other stuff, these formalities and so on, should be out of our way. And the argument I put, which is, again, Holmes's argument, is, and it's a deep argument here, not just one that he's applied to anti-terrorism, is that there is a great value in forcing people who take critical decisions to observe a whole range of standard procedures. That's what we ask of surgeons in intensive care and nurses and so on. And typically, if you see a case in the newspaper, it's because one or other system procedure has broken down. And in the case of law, we also make, as part of those procedures, as much light of day as we can put in. Or maybe not as much, because there is a difference between accountability and responsibility. And you can be very accountable, and that can sap your responsibility. But certainly, we want to avoid the circumstance where people who are dealing in operations which themselves not simply are to combat risks, but are risky in their consequences, be constantly aware that they might be caught, that they might have to defend what they've done according to pre-arranged or pre-settled procedures and rights and defences and so on, rather than, look, this is a very serious consideration, just squeeze a bit more
and we'll
tightly.
do what we have to. And of course, I mean, to be extremely crudely pragmatic, given that we live in an open society, if people operate in the dark and operate under emergency and operate foolishly and don't come up with good results, we get to know about it, and it tends then to delegitimise all sorts of things that might need to be done.
Yes.
I mean, I would have thought the way in which, I don't know whether you agree, but the way in which the federal police and the Minister for Immigration and the Howard government handled the Hanif case, which I've spent quite a lot of time thinking about, did an enormous amount to make more difficult action in the future. It obviously doesn't make it impossible, but it is raised in the community generally a real scepticism about how far you can believe and trust in those that you previously might have believed and trusted in.
And that too has, just like not everybody is subject to the same degree of infringement on liberty, when a government which professes and has, or at least the institutions have a long track record of fair dealing, starts to behave in ways which don't conform to that record, one level is general scepticism. But another level of some strategic importance is scepticism among exactly that target population that you want to help you.
Yeah.
Not every Muslim wants to help a jihadist. Not every Muslim wants to feel alien in the country that they have come to. And while that doesn't mean all bets are off, just do what you like, it does mean, I think, that if you have principles that you profess, you should spend a lot of time trying to make it clear that you do conform to them.
Yeah.
I'd read the paper today, and it confirms what a barrister I spoke to a few days ago told me, but I don't know, I don't have more evidence than that. Today was a report that there is a report about to come out of a committee chaired by Sir Lawrence Street, which examines the Ul-Haq affair, maybe both the Hanif and Ul-Haq affairs, I can't remember, which mentions that there is a lot of tension between the federal police and ASIO, because even though the federal police seems to have been involved in all sorts of murky practices in Hanif, the federal police are used to being brought to task by legal means, and ASIO isn't. And there's a lot of tension between what you do there, and this, to some extent, if it was a report, as I think it was, only on Ul-Haq, is brought as one of the reasons that Ul-Haq was treated the way that he was, that ASIO wasn't used to the discipline, if you like. And discipline is what it's about, isn't it? The discipline of doing things by the book.
Yeah, and of course, I mean, what you say in the chapter, and what I agree with profoundly, is that it would be dreadful if the way in which the authorities behave does drive some young men or women, not even young, into believing in the way in which this society can't be trusted and the rule of law doesn't mean anything, and that a kind of cynicism about the kind of society they're living in is increased. So
and it's part of the language. So often that sounds namby-pamby, but if you look at, we've had now quite a history of counterinsurgency operations, not in our own country, but in countries around the world, screwed up countries.
Yeah.
And the one in Iraq and the one in Afghanistan, both of them seem to be suffering great problems at the moment. Vietnam was a failure. One success was Malaya, and it was in Malaya that the man involved, who led the operation, said the major battle was hearts and minds. It was his phrase, I think. Anyway, it was the phrase that he used. And that's not to be forgotten within a society as well.
Yes. Now, the final question, I said an enormous amount of matters that I think are both extremely important and very sophisticated. But I want you now to be very simple. You've got the ear of the Prime Minister, but you've only got it for a minute. And what, in that minute or so, what would you want to say about how he should proceed in the area of civil liberties and the war on terror?
Well, I'm not going to give specific provisions, but there are certain, again, it's a matter of ways of thinking. I think you've got to assume that people involved in security will be governed by a logic of more is better. More of what they know best is better. More of what they do most centrally is better, and therefore that warrants scepticism. I think you've also got to assume, and that should be basis for a presumption, that criminal law is not a kid's game. been doing this stuff for a long time, and what that means is dealing with people who are rightly accused, some are falsely accused, prosecutors are often overzealous, and I think, again, there should be a presumption that they know what they're doing. I don't think any of this is absolute. That's why I often have difficulty being simple. I don't think any of it's absolute. That is, I'm not saying there is no circumstances where you should think we can't afford the constraints that we keep for normal times. But that should not be a forward position. That should be a really last-ditch position. And when done, it shouldn't be. And I think this is very important for the rhetoric, which is not a small thing because it's to persuade people. We have had, over the last several years, a rhetoric which seeks to put forward, that is, make the foreground rather than the background, the need to do extraordinary measures, and the need that, and the supporters, for example, the people in the press, commentators in the press, very often when they lambaste the civil liberties lobby, they say they don't understand this is a serious business, serious people. McKilty says this himself, and I quote him in the article, other people at the coalface and all these commentators getting in the way. I think that it's precisely then that a Prime Minister and an Attorney General should say, even if it is a circumstances where they think really business cannot be as usual, they have to say it in a way with a heavy heart, explain why, put procedures in place which allow, even if it's after the event, it may have to be after the event, we have to do something now and we'll answer to courts or to Parliament or to people later, but to put them in place. And I think that matters. I think that that would legitimise, in those rare circumstances where it may be necessary, people actually doing more than we would want to think in advance they should be allowed to do.
Thanks very much.